My name is Barb Van Hoy, and I work with the City of Colorado Springs Housing and Homelessness Response Department. We are one of the agencies that collaborate to host these Renter Rights 101 events quarterly around the community. And part of what we do is each of the agencies does various kinds of services for folks, and we ask each of them just to very briefly let you know what are the services available and how to connect. Just really super quick. Lisa, would it be okay if I brought you up from Community Economic Defense project? Yes. As we get our projector going, we'll get it going soon.
We also have like many tenant-based services. So if you're a tenant and you're having maybe some experiences with your landlord that aren't so great, maybe there's some bad landlord behavior, some pressure that you're receiving. We started putting on these monthly housing legal nights. So also in collaboration with Barb, with the city, with Pikes Peak Library District, and with Colorado Legal Services. We are here at these quarterly meetings, but now we are also putting on monthly housing legal nights. So at the monthly housing legal nights, there will be a Know Your Rights presentation, similar to what we're going to see tonight. Each month there's a different theme. And then there will also be an opportunity for you to ask the lawyer more in-depth questions. Yeah, and those are happening monthly, the second week of the month, and we could also support you in applying for a results. So if you have any questions, you can talk to me afterwards. Thanks, Barb.
Thank you. And we have someone new from the Independent Center.
Yeah. Hi, everyone. My name is Emma. I'm the advocacy specialist at the Independent Center. We are a nonprofit disability resource center. So we provide lots of and we are in the business of helping people in whatever way we can. So
Thank you so much. It's coming from mine, and it says that everything's off.
It might be the speaker.
Okay. It's just that sort of day. Sandy, I didn't know if you were prepared to talk about what is that the legal, and would you mind, just because for folks online, we do have a few folks joining us online. I think they'll be able to see you better. In fact, you could stand here and they could even see you. That's a video on.
Okay. Hi, I'm Sandy Hancock with Pikes Peak Library District. Our law resources librarian is out, so I'm stepping in for her. But PPLD does offer a variety of assistance for questions that you have. Deb is not a lawyer, so she can't give any advice, but she knows everyone in the community, and she's really well versed in all the different resources that we do have available for you. And her information will be available at ppld.org under legal resources. So if you have any questions afterwards, please come and ask. Okay.
Thank you. And I definitely recommend if you have any sort of legal issues or questions, they have a lot of resources there at the library. And I will just mention that the City of Colorado Springs Housing and Homelessness Response Department does maintain a web page with some housing help and resources. The city generally does not provide services, but with some of our federal funds, we're able to support some of the work in the community and also just help to refer folks to who they can get some help from, which are many of the other organizations that we're doing this work with. And really the city's interest is in reducing conflict between landlords and tenants, and also trying to just help support housing stability in general so that everyone knows what the rules are in order to be more effective or in order to stay more stable in your housing. And I do want to let you know that I will be posting the video of this presentation on the city's website. You'll also be able to access the slides that Clinton is going to go through. There's a lot of information. It's very dense. He goes very quickly because he wants to cover as much as possible. Please hold your questions toward the end, and then we will answer them toward the end. And also just a reminder, Clinton will not be able to answer questions about your specific situation. So if you are having some issue or problem, this is not the place where you can get help with a specific issue, but it's really an overall overview of what is the law and what are some of the things you need to pay close attention to keep the peace and stay housed. And to introduce Clinton, I just want to say that we are so grateful for the work that he does and his presentations. Clinton Albert is an attorney with Colorado Legal Services. He has been working for many years in this realm, representing renters, and he has a lot to share with us. So with that, I will turn it over to Clinton.
All right, thank you, Barb. Let me get the presentation up here. All right, perfect. Good evening, everybody. My name's Clinton Albert. I'm an attorney with Colorado Legal Services, and promise we're going to start moving through slides. So just to kind of iterate a couple things here, this presentation's for informational purposes only. I can answer informational questions. If you're thinking, what's the difference between information and advice? It's when you ask me to apply your facts to the law and then tell you if that's okay or not. I can tell you what is or is not okay, but when you ask me, is this specific thing, where does it fall? That's when we cross into advice. And also there's a lot of times the answers aren't just in a vacuum themselves, and they require a thoughtful analysis of both the facts and the law that apply to the case itself. So if you do want to seek further advice, you can certainly apply with Colorado Legal Services for assistance, and the contact information is there on the slide. You can also apply on our website at coloradolegalservices.org. So tonight we're covering lease literacy. So what all are we talking about? We're talking about applying for a residence. What do we do before we sign the lease? What about the lease late fees? What types of clauses are going to be red flags? What cannot be enforced? And then we'll end with a brief bit on security deposit as well. All right, so the first step in any kind of lease is applying for one. So at this point, this is where the Rental Application Fairness Act, it governs what can and cannot take place. There were pictures on this when I developed it, so we'll see if they decide to make an appearance later. So these are the rules where it sets out, hey, this is what can and cannot occur. Great. Oh, I guess all the pictures can't be displayed. Cool. All right. Well, they're on the handouts. Landlords aren't able to charge a fee for an application unless the fee is used to cover the entire fee is used to cover the application processing costs. Cannot charge different amounts to different tenants or different units offered by the same landlord. So the landlord has to have the same application fee across the board if they are in fact charging one. And also if as a tenant, if you're using what's called a portable tenant screening report, which we'll get to in just a couple slides, you do not have to pay a fee and they shall not charge you for one. They're also supposed to provide a receipt for the application fee and also an itemization of the costs, the anticipated costs, or the actual cost for processing the application. And then if there's any kind of remainder, they're supposed to make good faith efforts to return that leftover amount within 20 calendar days. So tenant portable screening report. This is a consumer report that is generated to avoid application fees. And this is something that can be generated from a number of services. I don't have any specific recommendations. I would just search out there what's available, maybe start with credit bureaus as a first stop. So this is something that you would have to request. A potential landlord wouldn't do that on their own. But this is a report that's going to contain name, contact information, employment, income verification, last known address, and then rental credit and criminal conviction history for each jurisdiction indicated in the report as a prior residence. Convictions is important there because arrests are not a basis to deny someone and is not a basis to deny an application. So landlords are required to accept a portable screening report. They may require additional kind of updates or attestation such that the report be made in the 30 days prior, that it be made directly available to the landlord from the third party that generated the report, that it be made available at no cost to the landlord, and or a statement from the applicant saying, hey, none of the information here has materially changed since the report has been made. So landlords they're not allowed to charge a fee when we're using this screening report. And they have to tell you as an applicant that you have a right to use a screening report. They can't charge an application fee for using one. And they cannot charge any kind of other fee, whether that's a processing fee to use that screening report. This has to be in a location. This has to be a written advisement. So it either has to be, on the website, in the advertisement for the residence itself, or they tell you verbally and then follow up with a written statement to that effect. Here's the odd little exception here. They don't have to accept portable screening reports if they only accept one application at a time and refund the total application fee within 20 days of declining the application. If you're thinking that sounds a bit strange, I've never seen that. I haven't either. So
that doesn't make sense. I'm not even gonna write that down because it doesn't make sense. I think you should do something with that and find out what's right.
Okay. All right. So if a landlord gets their own report, they have to provide a tenant with a copy of that. And that copy also has to have another advisement advising you of your right to dispute the accuracy of that report with the credit agency. So if your application is denied, that decision must be in writing and provided to you. The landlord has 20 days to provide you with that decision. And the decision also must provide the reason for why the application itself was denied. The reason for that is that if there's something erroneous on there, you have your name's John Smith, and they showed every criminal conviction for John Smith, and that's not me. I'm a different John Smith. Here's my background report. So that could be you'd want to be able to dispute that. Also, a violation of parts of the Rental Application Fairness Act is going to constitute unlawful discrimination based upon income. So that would be an unlawful housing practice kind of in Colorado's fair housing law. And that's for certain parts of the rental application fairness, such as income source. And then also, if there is a violation of the Rental Application Fairness Act, the possible penalties there by the prospective tenant are $2,500 plus court costs and reasonable attorney fees. So these can be expensive mistakes to make. If you are on the receiving end of one of these mistakes, you have to give the prospective landlord a notice saying, hey, I'm going to file a lawsuit within 7 calendar days based upon your violation of this act. Here's what you did wrong. The landlord who corrects or cures this violation, they're not going to be liable for that $2,500 amount. They just have a $50 penalty to the tenant or to the applicant at that point. But that could wind up being the reversal in a decision of whether or not to accept or deny the application. But if you bring a meritless and bad faith claim against the landlord under this act, then you're going to be responsible for the landlord's court costs and attorney fees in defending against that lawsuit. So that's a little bit, it's a brief bit about the application. Just some other information about the application itself, as far as what can be used to deny an application. It's going to be credit history from the past 7 years, and then also criminal convictions within the past 5 years, except criminal convictions related that are homicide related. Stalking would require somebody to register as a sex offender, or methamphetamine production, distribution type offenses. Those convictions, they can be a bar to a residence for your entire life. So those are very specific convictions, but a theft conviction from 10 years ago isn't really going to do anything. That is not a basis to deny an application. So we've now gotten our application accepted. We've gotten the lease agreement. This lease agreement is going to be voluminous. We've seen them. They are now approaching, 50, 60, 70 pages. One thing to keep in mind, first of all, and this is just for any folks that are participants in the address confidentiality program. The lease itself is going to identify the property. It is not going to have the confidential address on the lease because it needs to have the actual property address. However, if you are a program participant, then you should make sure to tell your landlord that this new landlord that you do participate in the address confidentiality program. That way, any correspondence or any notices that would need to be mailed would be mailed to the confidential address and not the actual address. If you're watching this right now and you're thinking, what is the address confidentiality program? Do I have to worry about this? If you're asking the question of what is the program, then it doesn't apply to you. It's a program for survivors of violence to be able to escape the continued abuse. All right, so we're reviewing the lease. We need to read through each and every page. It's a lot. It's going to be in fine print. Make sure that you have anything you need to read it and take the time. This is a document that's going to be legally binding, so you want to make sure you understand a lot of the terms in it. What are you signing up for? Is this going to be a year-long lease, month-to-month lease? Make sure that the dates of the lease are actually complete, that there's not kind of a digit missing for many years. That kind of discrepancy can create a problem down the line. If you're reading through it, you see something referenced like house rules, building rules, common area rules, lease addendums. Make sure to cross-check that you have those documents, right? Because once you sign the lease, you're agreeing to the documents that you don't have. Like I said, just to iterate there, if you're looking through it and there's incomplete information, make sure that that information is completed. Alert the landlord to any kind of alterations you're making and make sure that both parties sign it. If there are any changes, make sure those changes are made before the lease is signed. Most written leases will have a clause in it that says this agreement contains this document contains all agreements between the parties, and any alterations or amendments must be in writing and signed by both parties. So that means if you're signing your lease and you're getting some verbal assurance of, yes, this thing, this item is included in your lease, it is included in your rent, but you don't have a written promise of that, it doesn't count. And you're not going to be able to make it count because you already agreed that any kind of change or amendment is going to be in writing. There kind of, if we're looking at two bigger types of tenancies here, we've got residential and commercial. Commercial, we're not talking about tonight. Business, non-residential tenancies. So residential is what we're talking about. There are kind of two bigger groups of lease agreements within residential. You've got oral leases and you've got written leases. So, okay. Oral leases are valid. You can do that. There are going to be some setbacks to them. There are some pitfalls when we're dealing with these leases. An oral lease cannot be longer. A verbal lease can't be longer than a year. So if you're talking with a landlord and they say, yep, you can just live here the rest of your life, that's not going to be an agreement that you can enforce. That's just not. And more often than not, even if more often than not, if there is a dispute over the length of the lease, a court is likely going to look at it as a month-to-month lease. Unless there's something in writing, text messages, email saying, yep, just making sure we're good for a year, for 2 years, for 6 months, 9 months, whatever it may be. And the reasoning for that is that the court's going to look at what information it has. Since we don't have a written lease to go off of, what else do we have? Well, we have a monthly rental payment that's made. So because that rent payment is made every month, that's going to be kind of one of the very distinctive facts there to say this is a month-to-month lease. This is not a 1-year lease or a 2-year lease, anything like that. Any kind of additional conditions are going to be difficult to prove, such as if there's any kind of outbuildings, use of the outbuildings. So if there are differences, you probably just want to, if there are details to the agreement, you probably just want to confirm them in an email or even just something in writing. Even something as small as a text message could be very useful down the line. Even if you get a double-clicked thumbs up emoji, that can be upheld as an agreement that in court. I think a lawyer did that once and it cost his client 6 figures. I don't think that's going to happen in any of our dealings with our landlords, but just to express the importance of getting something in writing. An exempt residential agreement, this is going to be something that falls under a written lease agreement. This cannot be a verbal one. It has to be written into the lease itself. Really what this does is it says, hey, if you fall behind on rent or if you violate the lease, you have a 5-day cure period and not a 10-day cure period. This is only available for single-family residences. So no apartments, no condos, and the landlord has to own 5 or fewer single-family rental homes. So what needs to be in a lease? As we're looking through it, what do we need to see in this lease? So, one, we need to actually get a copy of the lease for ourselves. Your landlord is required to provide you with a copy of the lease within 7 days. If you can, as you're signing it, if you want to scan it with your phone, if you've got the ability to do that, go for it. A lot of the smartphones are able to scan documents, so that may be something you can do as you're reviewing it. Alternatively, really make sure that they either run off a copy or that you get it emailed to you and confirm that you can review it. Make sure that you get a copy that is signed. All right, if you have an unsigned copy, you don't have proof that it was signed. All right. The lease must include the name and address of the landlord or the landlord's authorized agent. This is critically important if you're trying to figure out, hey, I don't have any hot water. Who do I tell this to? How do I send them a letter? And then if that information changes, either there's a new landlord or there's a new agent, that information must be provided to you within 1 business day of the change, or they must post the information on the premises. Also, your lease has to include a statement that Colorado bars income discrimination unless the landlord has less than 6 total rental units. Okay, so those are what has to be in a lease. All right. Basic lease also provisions also need to be in there. Rent, location, term. Otherwise, you're missing kind of pretty critical terms of the contract. But what cannot be in there? Or more importantly, if you see this in there, this cannot be enforced. All right, this is barred by law. So a lease can't assign you a penalty just from giving you an eviction notice or by filing. There can be a posting fee, but there cannot be a penalty for it. If there is any provision that awards attorney fees, the attorney fees must be what's called a prevailing party statute. That means that whoever wins the case gets reasonable attorney fees. It used to be that leases were written that if we file an eviction case, you agree to pay us all of our attorney fees. That is no longer allowed. Also, a lease cannot have anything that attempts to waive the following rights. This one seems a little bit, you may find this to be a half measure, and I can appreciate that, but you can't waive your right to a jury trial unless it's for an eviction. So you can, the current state of the law is that a lease, and your standard leases do, but your lease cannot waive the right to a jury trial, except that it can waive the right to a jury trial for the possession portion of a eviction case. So the actual eviction case. If you're thinking, great, what do I get a jury for? General breach of contract, warranty of habitability. If you file a wrongful withholding of security deposit into county court, Rental Application Fairness Act, you can get juries for those issues, just not for the actual eviction itself. You can't waive your ability to join or litigate any kind of joint class or collective claim or action against the landlord. Can't waive your implied covenant of good faith and fair dealing. That is the duty that your landlord will act in a manner that is accepted by industry standards. All right, they're going to act like a landlord. They can't waive the implied covenant of quiet enjoyment. That is that you get to use your apartment as an apartment. That doesn't necessarily mean that, and this is where actually, except that a written agreement may provide that a landlord is not responsible for any violation of this covenant that is committed by a third party acting beyond the reasonable control of the landlord. So say you're renting a house, the house backs up, or you're renting a townhome, the neighbor is a different owner, and your landlord has no ability to control that neighbor. So if that neighbor is just creating chaos, that doesn't fall upon your landlord. You also can't waive your right to mandatory mediation if you're a tenant who receives assistance, so SSI, SSDI, or TANF, and you tell your landlord in writing that you received that assistance. We're still in lease clauses that are banned, so these are not allowed to be in leases. If they are in leases, they cannot be enforced. All right, so if you don't provide, if the lease says you have to provide 60 days of notice of non-renewal, and if you don't, we're going to charge you 2 months rent. That's not allowed. Okay? If you don't terminate your lease or if you don't not renew, I hate double negative. Sorry about that, folks. Let me try to think of a better way to phrase this. If you are trying to tell your landlord, I am not renewing my lease, and you tell them in less time than what the lease says you have to, it's not going to be some large penalty that's in the lease. It would be, what would your landlord's actual damages be based upon that late notice? Did I lose 15 days of potential income because I wasn't able to get the property prepared to put on the market in time? And they would have to show those actual losses as a result of the late notice. They're not allowed to characterize anything other than rent as rent. Rent is what you pay for the roof over your head. Everything else is not rent. You can't be charged a markup or fee or service for a third party, except that it may require that you pay an amount that is 2% of the billed or marked up fee. You also can't pay any fee, amount, or charge that violates the Colorado Consumer Protection Act as it relates to landlords. If you're saying, well, what about this one? This is also why I'm unable to answer exact questions in a setting like this, because a lot of the times my answer is, that's a good question. I'll have to look into that and get back to you on it. All right, so you are not, if there is any provider operating under any kind of voucher or subsidy program, they cannot try to evict you for the non-payment of utilities. They can't try to recoup any costs associated with mediation. The landlord is required to pay the costs of mandatory mediation, and tenants are not allowed to pay, not allowed. Yes. No. We're going to get to late fees. That's in here too. That's a great example of an informational question. Can your landlord charge you for a late payment from the Public Housing Authority? No. All right. This is an odd one. If you're thinking, well, I guess if I'm the tenant, it doesn't really affect me. if I die during the term of my lease, other than the death. So this is more of what happens to the lease itself. Let's say you're living with somebody, you're allowed to live there, but you're not on the lease itself. So the landlord is allowed to, what they're not allowed to do is require any kind of payment of liquidated damages, accelerate any rent, for a period that is beyond the end of the month or more than 10 business days after the dwelling unit's vacated, after notice to the landlord of death, refunding any kind of move-in discounts, or any kind of early lease termination fees. Also, this is one exception where landlords don't need to go to court to get an eviction order, where they can go to court, or they don't have to go to court if they get notice from the tenant's personal representative of the surrender of the premises, or 30 days after the death of the tenant, when the rent remains unpaid or most of the property has been all moved out. Unless the death resulted in substantial damage to the property, they can recover. They can withhold damages out of the security deposit related to damage caused by the death. All right, so the rules that we're talking about don't apply if we're thinking more of the owner of a duplex, triplex, or a home with an accessory dwelling unit, like a converted garage, where the owner's on the property as their primary residence, or their primary residence is on the same lot, similarly there. All right, late fee time. So late fees have to be in your lease. And this is a clause that you need to read very closely. All right, late fee means the money that you pay when you fail to timely pay rent. Rent means the money or any other consideration, whether you're doing work around the property, to be paid for the right to use, possess, and occupy a dwelling unit. A late fee is distinct from rent and cannot classify late fee as rent for the purposes of an eviction for non-payment of rent. Before we get more into late fees, just real quick on to rent increases. Sorry, I stuck this in and I am now realizing I put it in the wrong place. During the lease term itself, cannot raise your rent. Landlord has to provide you. Also, if you're on a month-to-month lease, your rent cannot be raised more than once in any 12-month period. The rent has to be raised. You have a right to 60 days notice of the rent increase. It must be written notice. It can't be a phone call. And your landlord is not allowed to terminate your lease with less than 60 days notice for the purpose of increasing your rent. Okay, back to late fees. Sorry about that little detour, folks. All right. When you're reading your lease is going to tell you when your rent is due. The grace period that your landlord may say is not when your rent is due. Your rent is going to be due on the 1st. And your rent is going to be due on the 1st because then your landlord's going to tell you, yeah, but you have until X to pay it. What they're saying is we are not legally allowed to charge you late fees until 7 days after the rent is late. So your rent is due on the 1st. You cannot be charged late fees until the 9th. Right? You pay rent within that 7-day period, though. You can't be charged late fees because even though the rent is late, it's not late enough for late fees. So here's what landlords are not allowed to do in regards to late fees. So this is where we're reading our lease agreement. Late fees have to be included in the lease agreement. So I said they cannot charge if you have a lease agreement that says, hey, rent's going to be due on the 1st, and if it's not paid by the 5th, we're going to charge you $50 a day until it's paid. That's not going to be enforceable, but your better practice is just to not say anything, and we'll get to that. So rent can also the late fee can't be cannot be more than $50 or 5% of the late rent. Not just the rent, the late rent. So how much of it is late? So if it's 50%, that's going to mean the late fee's lower. And the late fee has to be disclosed in the rental agreement, which means if the late fee is not disclosed in the rental agreement, it doesn't have to be paid. Also, if the late fee clause in your lease agreement does not match up with the law, if there are parts of it that are attempting to not follow the law, then that late fee clause is void and unenforceable. We'll kind of walk through why that matters. Landlords aren't allowed to try to evict a tenant or remove them from the premises for the non-payment of late fees. Can't end a tenancy in a mobile home park because of non-payment of late fees. Can't charge a late fee on a late fee. Oh, sorry, wrong one. Can't charge interest on a late fee. Also can't charge late fees on unpaid late fees, and cannot charge late fees for non-payment of any portion of rent that a rent subsidy provider is responsible for paying. That may get into a gray area if you are not in good standing with the subsidy provider. But they're not allowed to charge late fees for that. They also can't charge more than one late fee unless we're still within that up to $50 or 5% of the unpaid amount. Interest on a late fee, can't do that. They also have to disclose the late fees being charged within 180 days of the late fee being charged. So if the late fee clause in the lease doesn't match up with the law, then it can't be enforced. All right, you can bring injunctive relief to stop them from charging late fees, but let's think about this. Any late fee has to be in writing in your lease agreement. If the late fee paragraph is not compliant with the law, then the late fee then you cannot be charged, and it's not enforceable. If it's not enforceable and it's void, then there's no late fee clause in your lease agreement. If there's no late fee paragraph in your lease agreement, then you cannot be charged late fees. Right? So if you are reviewing, but now keep in mind, where are we at in this timeline? We're reading our lease agreement. So we can tell our landlord, hey, this doesn't match up with the law, or we can sit quietly and if they do try to charge us late fees, say, no, this is void and unenforceable, and you cannot charge me any late fees. Here's the last part. So what are the possible penalties for illegal late fees? So a landlord who charges an illegal late fee or charges a late fee in an impermissible manner, it's going to be a penalty of $50 for each violation. As a tenant, if you bring this to your landlord's attention that, hey, you've charged me an illegal late fee for this reason, you have 7 days to fix the problem. If you don't, I will pursue action. You can then file a lawsuit for any kind of damages. Also, there will be at that time, the penalty goes from $50 to could potentially be up to $1,000. Also, court costs, attorney fees, and any other equitable relief the court finds appropriate. So how does a landlord cure an illegal late fee? As a tenant, you've got to let the landlord know first, this is illegal. The landlord has 7 days to fix the problem. That time period begins when they get the notice. That doesn't mean that the landlord can avoid that initial $50 penalty. What it does mean is if the problem's fixed, they can avoid the lawsuit and the $50 to $1,000 penalty and possible other penalties. It also doesn't mean that the landlord can change the terms of the lease in the middle of the lease agreement. Remember up front when I was really hammering home the point of if it's not in writing and you have a written lease agreement, it's probably not good enough. Well, if the late fee section of the lease is void and unenforceable, and your landlord says, well, oh, I'm sorry, that was my mistake. Let's just fill out this new one then. You don't have, why? You already have the lease agreement. What's in it for you? All right. So just as we're thinking about a lease as a contract, as we're thinking about this relationship as a business relationship, that's how we handle it. I already have my contract. I get to purchase the property. So if you're a landlord, make sure that you're double checking your lease agreement as well to make sure that you don't run afoul of this, because this can be expensive. Please hold all questions till the end. And when I say this can be expensive, this is not every case. This was an exception. But I had seen one individual's bookkeeping was very problematic, and just based on the penalties alone, the claim was $32,000 because there were 16. It was just thousands of violations. All right. If you are charged illegal late fees, it is a defense against an eviction. And this can create a set off where if you're being charged, if the eviction is for some kind of non-payment, but you've been paying illegal late fees, well, we've got the illegal late fee that we should use against that debt. And then we should also start be tacking on those $50 penalties to it as well. Hopefully get to a point where, hey, actually, I don't owe you this rent money because you've been charging me these late fees the whole time. All right, moving into the security deposit realm. So security deposits, it's the function of a security deposit is to guarantee your performance under the lease. It is not your landlord's money. This money is just kind of set aside as a promise that, hey, I'm going to pay my rent every month. I'm going to move out when I say I do. I mean, I'm going to clean the place up like we agreed in the contract. Landlords can deduct for normal wear and tear, but what is normal wear and tear? It's what happens based upon living in a home. Carpet's going to get the wear marks, right? When we walk the same path, that path gets worn down. What is not normal, or it does not include uncleanliness that renders it substantially less clean than the dwelling unit when the lease began. So underneath the stove, the oven, the difficult places to reach behind the fridge, those cleaning costs are going to be not normal wear and tear. Also, what is it not? Punching a hole in the wall. That's not normal wear and tear. That's intentional or just not good practice. Landlords are not allowed to charge more than 2 months for a security deposit. Okay, so 2 months rent is the maximum security deposit. Even if someone's trying to work with you on, all right, well, your credit's a little iffy, but I'm going to raise the security deposit to kind of hedge against that. They're not allowed to do that beyond 2 months. This is new and substantial. So if anybody has seen one of my prior presentations and we got to the point where we got to this point of taking photographs, I would have told you take a photograph because you don't have a right to a walkthrough. Well, you've got a right to a walkthrough now. So upon a landlord or a tenant's request, if it is reasonable and practicable, the landlord and the tenant shall conduct a walkthrough inspection either in person or via like video phone or something like that of the unit. This is to identify in writing any damage or defective conditions that are beyond normal wear and tear and that did not pre-exist the tenancy. Landlord shall provide a walkthrough inspection report at the tenant's request at a time that is mutually mutually convenient to the parties. And after the tenant has had the opportunity to remove furniture. So that's where you want to put in writing. This is what things are looking like at the end of it. If you request a walkthrough and your landlord does not agree to it, then, or they otherwise wrongfully withhold a security deposit portion of this, wrongfully withhold a security deposit or a portion of it, the landlord forfeits the right to withhold any portion of the security deposit. So refusing to do a walkthrough, so it would be best practice, take pictures before you move in, before you put one box on the ground. All right. When you move out, request that walkthrough with your landlord too. When you move out, request the walkthrough again, request the inspection sheet, take another set of pictures. And there's the statute. I put it on the slides for folks to just be able to review that. So why can your landlord withhold a security deposit? And again, just to kind of bring us back to, these are all kind of seemingly random topics. We're reading through our lease agreement. All right. So these are some of the main things that a lease agreement is going to cover is the money. All right. And if you see your lease agreement having a lot of lease clauses where you go, hey, I know that's not allowed to be in there. This might be a red flag that this may not be the business relationship for you to enter into. Because if the lease agreement's problematic, maybe the tenancy itself will be problematic. And if you're right, if you're sitting here thinking, well, shoot, I'm writing a lease myself, make sure that your lease is compliant with what's going on, because that's going to save you a lot of headaches down the line as well. Because once the lease is signed, that's the binding agreement between the parties. And as a landlord, since the landlords are the one writing this, you're going to be presumed to have more power in drafting of this agreement. All right, so landlords are only able to, going back to security deposits, and when are they allowed to be withheld? So we're reading through our lease agreement, make sure that there's nothing outside of here. That's the non-payment of rent, the non-payment of utility charges, non-payment of other lawful charges listed in the lease agreement, or for necessary repair work for damage or defective conditions that exceed normal wear and tear and did not pre-exist the tenancy. A whole lot of words to say to patch up the hole that I punched in the wall. All right, so what is the wrongful withholding of a security deposit? I've been using that phrase. It's not just the withholding, it's the wrongful withholding. So the law says it is a wrongful withholding of the security deposit if the landlord fails to provide the written accounting statement of deductions. Again, remember, we're reading through our lease agreement because by law, you're supposed to get your statement or your deposit back within 30 days, but your lease agreement can write that timeline up to 60 days. All right, so and honestly, years ago we were doing one of these, and I had a landlord in the front row, and she had her tenant move out the day prior, and she was reviewing the lease, and she asked, says I have 3 days. I wrote 3 days instead of 30. She wrote 3 days instead of 30 and agreed to it. So she returned the deposit within those 3 days. Also, upon tenant request, this all relevant documentation, that's going to be requiring the receipts, the work orders, the actual cost to support the actual withholding of the deposit. If a tenant or if a landlord provides a written statement that fails to list the exact reasons, if it just says, you know, remediation of property, what's that mean? Also fails to, if there's a failure to return the difference between any sum deposited and the amount retained within the time provided by either law or the lease, or retains any portion of a security deposit in bad faith. So what happens when we get to this part? Sorry, folks, my voice is getting a little scratchy on me here. So a landlord is going to retain a security deposit or any portion of it in bad faith if it unreasonably exceeds the amount of the actual damages the landlord incurred, is retained without actual cause. Just saying, yeah, this is my annoyance tax or something like that, is an amount that the landlord knew or should have known exceeded the actual damages the landlord incurred. This is a 40-year-old carpet, so I'm going to charge you $15,000 for the replacement of the carpet. The actuarial tables on that, meaning insurance folks determining how much things are worth, says that it's not worth anything at that age. Or is the security deposit is retained solely or in part for any unlawful, retaliatory, or discriminatory purpose. Penalties here, so we're looking at treble damages. That's going to be 3 times the amount of the wrongfully withheld portion, right? If you have a $1,000 deposit, $1,000 is withheld. A court finds that $500 was wrongfully withheld, then you're looking at a $1,500 claim, together with any court costs and attorney fees. Again, similar to the late fee issue, you have to tell your landlord or former landlord that you intend to file this action within 7 days, unless they return the security deposit to you. In a court action, the landlord bears the burden of proving that their withholding was not wrongful and they comply with the requirements of the section. One thing to keep in mind here, make sure that you provide a mailing address when you move out. Your former landlord's required to send it to the most recent address that they are aware of. If I move out, I don't provide a new address. The most recent address that they are aware of is the address that I just moved out of. So that's where your refund's going to be sent. So make sure that you provide that new address. And then tenant you can file the action for the treble damages after receiving a notice after the 7-day period has expired. Okay, so the landlord is presumed to unreasonably exceed the amount of it. If the law is going to say, hey, that's unreasonable if it was greater than 125% of the actual damages incurred. Carpet cleaner cost me $100. I'm charging the tenant $150. We've got a bad faith. We've got a bad faith withholding there because this is more than the 125%. Even though that's a statutory presumption. So even though it's 120%, if the case goes to a trial on the matter, a court could find, or a jury could find, that even 1% over the top is unreasonable. The law just kind of gives a presumption of, hey, at 125%, we're going to start from a position that this is unreasonable. Landlord bears the burden of proving the actual amount of the damages. You've got to show the receipts. You've got to show the work. If exceeding the actual damages was somehow reasonable, then the landlord's only going to be liable for just that amount, not the treble damages. What happens if you get a new landlord? What happens to your security deposit? Nothing. Just goes to the new person. So the landlord has to transfer that security deposit to the new landlord or the new holder of the deposits within 60 days. And has to also has to notify the tenant, sorry about that, by mail the transfer, or can return the funds minus any lawful deductions to the tenant. I suppose that could happen. That would be a little bizarre if that does happen and you receive a security deposit in the middle of your tenancy from your now former landlord. I feel like it'd be safe to assume that the new landlord's going to be asking for a new security deposit. That would be an odd situation. You ask me, what do I do if that happens? Beyond that, I don't know. I would have to read the lease agreement because that would be bizarre. Again, these are the security deposit statutes. So we're reading through the lease agreement. You cannot modify your rights. Okay. We can go from 30 days up to 60 days, but we can't add in new parts, new basis to withhold security deposits, limiting taking away the right to treble, taking away possible treble damages. That's just going to be deemed as void. It's going to be something that's against public policy. The legislature has said, this is important for us to have this policy in place about security deposits. So if you try to change it, we're just not going to uphold that. Also, any cleaning for normal wear and tears or damage that pre-exists the tenancy is also going to be void. So that's again why it's really important to do the walkthrough, take the photos when you first move in, make sure that if there's an inspection checklist in your move-in packet, that you complete that in the time provided and turn that in as well. Make sure you keep a copy of everything for your own records. We've been talking about the leases and everything tonight. Document everything. If you can keep it in writing, great. All right, so if if a victim survivor of gender-based violence, so domestic violence, domestic abuse, stalking, and a tenant, and you terminate the lease early based on that, provide documentation of that, which can be a police report, civil protection order, 18-1001 restraining order, self-attestation affidavit, or a letter from a qualified third party. Then you're not going to be dead. And as a tenant, I'm sorry, folks.
No, that's okay.
Oh. All right. So as a tenant, you're not going to be responsible for any damage that was caused by the abuser, right? Also not there's a typo, sorry about that. Any damage during the course of an episode of domestic abuse, domestic violence, unlawful sexual behavior, or stalking, they can only make deductions that comply with the protections for victim survivors. And that is that they are allowed to demand up to 1 month of rent if they provide a statement within 30 days documenting actual damages. If there's no one left on the lease agreement. So if a tenant moves out, if the survivor moves out based upon these protections, and there's a roommate still in the lease agreement, or let's say the abuser is still in the lease agreement, then the full security deposit goes to the person moving out. And then the landlord can only pursue the damages from the responsible party. Okay, so as we're kind of thinking about this, a very fair question is, all right, well, how do I get my landlord to follow the lease? They're not following it. They're not doing what they say they're going to do. They've agreed to provide me with this pest control service. I pay for it every month. They don't do it. Right? Or my landlord says I have to do this. I don't. It's what the lease, it doesn't say that in the lease. But my landlord says it does. How do we enforce the lease? What do we do here? So there's a number of different actions, not a number like 50, but more like 3. But more often than not, if there is a dispute over the lease, that dispute will end up in court. If you are waiting for an eviction case to be filed, I would not recommend that for most issues. There are always exceptions. But an eviction case is about who has the right to possess the property. So if there's a disagreement over a term of the lease, and you're thinking, we'll just go to court and tell the judge what's going on, you could get that probably not the best way to go. Because you can still fight, you can still bring a lawsuit outside of an eviction case. Because again, we're talking about a contract. So if there's a breach of contract, there are actions. If there is confusion over the contract, then what we're talking about is a declaratory action. Is this the easiest thing in the world? No, it's absolutely not. I'm not sitting here saying that this is just learning how to tie our shoes, but this is where you're not asking the court for money. You're not or for your landlord to do anything like fix the heater or give me hot water. It's to get the court to say, that's what this lease clause means. Right? So if there's confusion over part of the contract, the court looks it over, the parties make their argument, and then the court rules, this is what the contract means. For other issues, charging illegal late fees, breaches of the warranty of habitability, a tenant can seek what's called injunctive relief. This is where you are seeking to stop behavior. So you are trying to get an injunction to stop your landlord from doing something. And the most common form of injunctive relief is going to be warranty of habitability. I've provided all of these notices. I have tried to get these repairs completed for these reasons. My landlord refuses to make the repairs. If you do not issue this order, I am at risk because I don't have a roof. I don't have a door. It's December. We have all of the windows are shattered out and there's broken glass everywhere. But that's an injunctive lawsuit where you're seeking specific performance. You're trying to get the court, because most of the time in a civil lawsuit, the court says, all right, you owe this person this much money. In an eviction, all right, you're the person or you're the party that gets to possess the property. If it's a replevin action, that's over property. All right, you're the owner of the property. I'm ordering you to give the property back to them. But in injunctive relief, if you're seeking an injunction, you're trying to get the behavior to stop. You're not doing X, I'm ordering you to do X. Or the inverse. If you are doing this, I'm ordering you to stop doing that. Those are more specific types of lawsuits. A lot of the times, like I said, what we're doing is we're seeking money. So for claims less than $7,500, you're likely looking at a small claims lawsuit. You can file it into county court. Small claims is designed for pro se tenants. If you get a copy of the slides, so if you register, make sure to put your email address back there and you get it emailed. I did include a link to the guide for this, just to walk you through it. The pleadings are a lot more, they are designed for non-lawyers. And in fact, lawyers are not allowed to represent folks, not allowed to represent the plaintiff. They can get involved later, but that's a whole different question. If the claim's greater than $7,500, it can go into county court. That jurisdictional limit is $25,000. If it's a case where the claim damages exceed $25,000, then you're filing into district court at that point. Is a general guide, but not any kind of hard and fast rule. The more money that's at stake, the longer the case is going to take. All right. There may be mandatory mediation. Well, there likely will be mandatory mediation for cases greater than $5,000. There may be required discovery responses, and once you get to district court. So that's why if you're thinking, well, I'm just going to go ahead and wander on over to district court, make sure that you've got the pleadings correct first, because you don't want to kind of limit or lose any recovery just by not knowing. All right, so these are just general tips, general practices. Start with demand letters before you get into court. That way there's a specific ask of, you've charged me this late fee. You have not provided me with 24-hour notice as stated in paragraph 4 of the lease, whatever that issue may be, and what it is that you are demanding that your landlord do or not do at that time. If there's just a disagreement over a term and things are relatively on good terms, maybe you can just go to mediation and work this out, get a new agreement signed. But a lot of times that's not going to happen, right? Litigation is costly, both in terms of your time, stress, and your money. So mediation may be a more cost-effective solution, but a lot of the times we're kind of past that mediation point, because if this could have been worked out, it would have been worked out. Damages need to be documented. This isn't a feeling that you have. This is a contract, right? So if you're thinking, what about my mental anguish? It's got to be more black and white than that. It's got to be what can we put down on paper? Certainly there are some claims can have punitive damages, which are damages designed to punish someone, as opposed to compensatory damages, which are, I spent $50 for a tarp because you didn't put a new window pane in to prevent the snow from coming in. But make sure things are documented, right? That's also why it's best to have things in writing. Just generally speaking, I think the best communication is written communication. This is a professional relationship. This is a business relationship. You want to treat it as such. Have things in writing, keep copies of everything for your own records. If you don't have a copy of it, it's going to be very difficult to prove that it ever existed. Just a couple things here, some odds and ends as we get closer to questions. If you think your landlord, and these are common pitfalls that, not common, but I've seen this kind of trip some folks up over the years. If you think your landlord has breached the lease agreement, that does not mean that the lease agreement is no longer in effect. That just means there's a breach. It doesn't mean you then this is not a tit for tat situation where you breach the lease, I'm going to breach the lease. And I'm going to breach the lease by not paying my rent. That'll show you. But then you get to court and you still owe that money, because the law says, I don't care. You should have filed a lawsuit about that breach. Why didn't you uphold your part of the contract? So just to kind of iterate that point, the contract will continue, and the breach would possibly create a lawsuit, whether that's a declaratory action to say, hey, you can't do that anymore, injunctive, or just I've suffered damages because you didn't follow the terms of our agreement. So I would like that money back. If you disagree with something that your landlord did, and it is not related to the warranty of habitability, I would advise against withholding rent. Chances are you're just going to rack up a late fee. And it could just get more costly. Again, as a general rule, I would say pay your rent today. And then the exception here would be warranty of habitability, because by statute, that has a carve out for withholding your rent. But my general kind of cliche is pay today and sue tomorrow. That way, there's no kind of claims against you for damages. Communication with your landlord during the tenancy, again, keep as much in writing as possible. Text, email, if there's some kind of portal, make sure to try to keep a copy of the portal message as much as you are able to. Some portals may not give you a copy of the text that you sent, but try to do a screenshot of the text before you hit submit. On our phones, the pictures have what's called metadata. The metadata will tell the date and time that it is taken. So if it really gets to that level of analysis, you would have that record of when that was submitted. Again, if you have a verbal or if you make a verbal agreement and have a written lease, the agreement is probably not enforceable. It's just probably not going to be worth anything. So if you fall behind on rent, you go down to the office and whoever's working behind the desk that day, it makes some kind of, if you come up with something, maybe we can work with you on it, then that's not going to be binding on anybody. There's nothing in writing, and your lease probably says that doesn't have any effect on it. At the end of the tenancy, again, request the walkthrough after removing furniture and before turning in the keys, and provide that forwarding address. Take pictures for your own records. What about terminating the lease agreement? So again, this is going through our lease because it's going to take us a long time to do it. If you sign it without reading it, it will not be a defense in court to say, Judge, I didn't read it. It's not going to get you anywhere. When can you end your lease early? By statute, there are situations if a breach of the warranty of habitability, protections for survivors of gender-based violence, military orders, but also your lease agreement itself may have situations and may set forth when can you terminate the lease early. That would be a section to look out for if maybe you have life prospects in the future where maybe life looks very different in 6 months from now, and you would like kind of an escape from this, an escape button on the lease, just in case. So again, like I said, there are other situations in the law that exist, but your lease itself may have kind of a no fault reason. Like, well, hey, if it's just not working out for you, you can always just provide this notice. A lot of the times they're going to have some kind of payment of costs or some kind of payment or fee to be able to terminate the lease early. If the lease termination is due to domestic violence, this is where they can terminate the rental agreement without further penalty. And if there are economic damages, actual damages disclosed within 30 days, then they may pay an amount not to exceed 1 month rent within 90 days. If a victim survivor of gender-based violence is being evicted and terminates their lease, that would make the eviction case moot, because meaning there'd be no purpose in moving forward anymore, because the lease agreement would be terminated and the tenant wouldn't have possession. So that would be a way to avoid an eviction if you're in that situation. All right, well, thank you folks for your patience and attention. And you've got my contact information up there. Gonna check the chat here for any questions.
So that's what you just did, took the slide down.
Whoops.
There you go.
Oh no, let's go back. Sorry, folks. Also, if you you have my contact information. If you contact me directly, say, hey, I saw your presentation the other week. I've got a question for you. I've really appreciate you remembering me and reaching out. I will tell you though, that the first step is going to be to apply for services because I'm not able to assist anybody unless they're a client or unless, I'm at, CEDP's, Housing Monthly Legal Night at the Ask a Lawyer section. Those are the rules that govern me. So hopefully that is enough time for anybody online. I am going to go through the chat. I don't see. Sure thing.
um, retaliation. My situation is that.
So we're about to get, you have driven us straight into advice territory.
Okay.
Okay, so, but let me,
There are resources available for like that are being retaliated against because they don't pay.
retaliation has its own. So retaliation, is statutory. So, that would be, shoot, I was trying to remember the statute off the top of my head, and I want to say it's 385409. But to answer your question, I don't know. Okay, and I don't know because from what you just stated, that's a broad range of subjects. All right, so we went from improper entry, potentially the duty to deliver possession. Also, if there's a contractual promise of that, that maybe we're talking about injunctive relief there. Maybe we're talking about declaratory action. If there's any kind of ambiguity or confusion over what the lease says, if there are economic damages, that could be there as well for a small claims action. But that would be one where if you're thinking the pain and suffering of that incident, that's outside of contracts. That's more, we're talking about personal injury, torts, car accident cases. So in retaliation, that's by statute, that's going to be in the warranty of habitability. There's a section under the warranty of habitability, which deals with retaliation. So if you were to utilize the library's law section, which I would highly encourage, I would recommend looking into the warranty of habitability. That would be where you'd find the statute on retaliation. And sorry to cut you off there, but I didn't want you to kind of relive all of that only for me to go, I'm sorry, that's too much. So wanted to kind of hedge off there because there's a lot there that it could cover. Yes, sir.
Several times in your end of your presentation, just now you're mentioning warranty of habitability.
Yes, sir. What is that?
Is there a definition
Yeah.
there?
Yes, the warranty of habitability that's in the statute. That's statutory. So, that's the law. So this is literally written down. This is not something that we all are assumed to know. And if you go to the city's website, the first so if you're looking for a resource on that or just some information on that, the presentation that last quarter was only warranty of habitability. So that video is up on the city's website.
Yes, it is.
CS.gov.
It's Colorado Springs, it's Colorado Springs.gov. Yeah. And also just in case, part of your question is what is that? It means what a landlord is required to provide in terms of habitability.
It's
Warranty is like, it's your promise of a good standard of, you know, when.
promise that your home is fit for a human being to live in. And that itself we spent a couple hours on that, a few months.
Yeah, so if you go to that website, for the city, you'll see if you scroll down, at the top, it will list this event. And then if you scroll down, there will be, videos and slides from many, previous presentations. Some of them are general, some of them are specific, like, for example, this one being about lease basics, another one about warranty of habitability. I think there was one that focused on new Colorado laws a couple years ago. So just scroll down that and you'll see links to lots of different videos and slides.
I expected somewhere in there quiet and enjoying.
Yes, I will.
Quiet enjoyment's just a little bit fuzzier. So what quiet enjoyment is the implied promise that you get to use your residential apartment as a residence. So that doesn't mean that you move in and your landlord, I think this may seem really odd, but this is the case law on it. So I think this was from the early 20th century where somebody moved into an apartment and they put in a printing press over top of the apartment. So he couldn't really sleep or do anything. So that's extreme, but if there's a situation where you're just effectively unable to live in your apartment from actions of your landlord or inactions of your landlord, then that's where we get into the covenant of quiet enjoyment. Any other questions for me this evening, folks?
Okay, this is all done for the benefit of the tenants. Is there any resource for
Landlords?
for landlords?
Certainly. And the information's for everybody, but I would say the Colorado Apartments Association is probably the main kind of lobbying wing for landlords. Also, your main kind of landlord firms around the state will have, normally will just post some more landlord focused information on their websites as kind of to entice new clients. Just if you were to search for landlord law firms, you would probably find they probably pay for Google to have their search results at the top. I just don't name specific firms that way. I don't give any appearance of endorsing somebody or anything like that.